Listed. Listed.
My lord, may I be permitted to mention one matter, my lord? The judgment regarding the Rani Birla Girls College has not yet been published in the
We'll see.
website.
We'll see.
Unlisted. Unlisted.
Understood. Lordship, may I be permitted to mention a matter? It is specially assigned to your Lordship and Lordship Roshanjit Bishaj. It was made returnable on the 22nd of this month. Your Lordship, it didn't come in the list. Can it be kept on this Friday?
Friday we'll see if it comes.
Your Lordship.
With regard to item number 3 of your Lordship, assigned matter, both parties here, Lordships. My lord, last occasion, my Lanefet complete his submissions, turn my lord, to submit before Lordship. My lord, in the gap period, my lord, I tried to find out from the lower court reports, my lord, there is a affidavit reply is there. Unfortunately or fortunately, my lord, that reply on the part of the petitioner was not been annexed in the original copy. Your Lordship asked me where you have stated. You show me the documents. Well, I failed to. I tried to find out, searching the copy, but thereafter, my lord, it is.
What do you want?
Just accommodations for. I have applied for the certified copy only for placing before Lordship, updating these affidavit and reply before.
How much time you need?
Maximum 7 days. Next returnable date.
For certified copy, 7 days is.
I cannot say 1 or 2 days because the dispose of matter, it was the RD section. Your Lordship, I can maximum next week.
Let him get it. Why didn't you next?
When the matter was taken up, in fact, I was also engaged as a chain.
So anyway, it is only in the interest of justice that it should be placed.
I completely bound to it. If there's something, then I should also refute to it.
So what you do is, in the meantime, you give a copy.
Obviously, after
So
I had
there
a talk
is-
with, in the morning, I had a talk with him. I disclosed to my learned
The
friend.
matter was
In nine. So kind of.
Number 1. Item number 1, my lord, Mr. Bishwarup Nondi is appearing for the petitioners, but my lord, he is currently engaged in court number 6. I'm praying for a short passover, my lord.
Lordship, I'm appearing for the state respondent, Lordship, on the last occasion. The matter is regarding the compassionate appointment. The last occasion, Lordship has already asked them to.
first case and you want a adjournment.
He is engaged in court number 6. Kindly, my lord, grant a short passover, my lord.
So he's seeking an adjournment before the division bench. You start. We're not going to adjourn this
My
matter.
lord, in this matter.
Sorry.
He just instructed me.
Then we'll record that nobody is appearing. This is not the way. You look at the order.
Lordship,
This is the way.
Just see the last order, Lordship.
Must have some sense of propriety. Matter has been heard. You have to give citations, and in such hearing, you are taking an adjournment before the division bench for appearing before a single bench. I don't know what is happening. Sorry, ask him to come immediately.
And number two.
Item number 2, my lord. I appear for the, I am for the respondent writ petitioner.
Lordship, we
You have been served with the paper book.
Yes, yes. Let paper books were filed within time. We were served also.
Not today. Not today. Let paper book is not here. Letters.
Printing the
ILS दिए थे। ILS दिए थे।
General motion item number 105.
You're for the respondent.
My lord, I am the respondent. On my lord, 3rd, the matter was taken. It was fixed on 10th because they wanted to file a supplementary affidavit.
Last day
Then
nobody
it was
appeared.
fixed on 20. Oh, you have come.
Supplementary.
So this is the supplementary.
Give a copy to him.
My lord, I got copy, my lord.
At least. భయం ఉంది. The supplementary video has been filed, my lord, because in terms of the because certain document has not been annexed with this, my lord. Now, my lord, kindly takes the impugned order once, my lord.
38, my lord.
We should proceed.
My lord. My lord, I only take your lordship's indulgence for allowing my junior to, my lord, pray for adjournment in court number 13 because see, unless he is there, I cannot.
Yes. What has happened? What led to filing of the OA? My lord. What led to filing of the OA?
Yes, my lord, kindly see, my lord. Allegation against this petitioner is, my lord, with regard to, my lord, he has taken money from some persons, my lord. That is the whole allegations, my lord. Thereafter, my lord, the criminal case is pending. Charge sheet has been filed. In the meantime, my lord, what happened, my lord, the government of the finance department has regularized his service and, my lord, his leave that has been calculated as everything has been released, my lord, and not only that, my lord, he has been practically exonerated from all the charges, wherein, my lord, the charges are very serious in nature. Tribunal, my lord, without going into all this, on the basis of those two letters, my lord, has passed the order. My lord, kindly come to the last page 242, last paragraph, my lord.
Yes.
As such, the instant application is not tenable in the eyes of law and is quashable and quashed and set aside, keeping in view of the withdrawal of the suspension by the review committee chaired by Chief Secretary and allowances, salary and other benefits given to the appellant as per ROPA 19. The respondent number 1, the Additional Chief Secretary, Department of Finance, is directed to treat suspension period spent on duty and his arrears, if any, be released expeditiously, but positively within 3 months from the date of this order. On the basis of that order, my lord, wherein, my lord, if his lordship takes the charge sheet, my lord, that is at page 210, my lord.
Charge of the DP is otherwise.
It starts with, my lord, page brief facts has been stated in page 213, my lord.
Just 1 minute.
Lord, sorry. আরে সবই কর তোরা।
Yes.
But the allegation lordship has seen, my lord. Such a allegation and ultimately, my lord, a case under section 713(2) read with 13(1)(d) of the Prevention Corruption Act has been established. Now, my lord, this trial is still pending. Now, during pendency of this, my lord, the tribunal has come to a conclusion without going into verifying all these documents and all, only on the basis of the my lord, the letters that has been, my lord, in my supplementary affidavit, my lord, has come to a conclusion that he may be exonerated from all these charges. Maybe, my lord, the chief secretary and all said this, my lord. That does not mean, my lord, that after going through all these documents and all, my lord, tribunal has come to a conclusion on the basis of these two documents that he has been, since the chief secretary has released him, so I will also release him.
And where is the letter of the chief secretary?
But kindly comes to page 41 of my supplementary affidavit, my lord.
Yes.
Last paragraph, two paragraphs, my lord. And whereas the review committee chaired by the Chief Secretary West Bengal has carefully considered the instant case and recommended withdrawing the suspension of C. So that his service may be better utilized in public interest. And thereafter, my lord, now therefore, the governor is pleased to revoke the order of suspension of with immediate effect and direct that he may be allowed to join his duties on the conditions that the treatment of this period under suspension and drawal of his pay and allowances during the said period and consequential benefits, if any, will be subject to the outcomes of the criminal proceedings and the departmental proceedings. He is hereby allowed to draw pay at the same rule as he was receiving on the day of immediately proceeding his suspension, and he shall continue to draw a pay and same shall until the next date of so and so in otherwise eligible.
What is the date of the charge memo?
Charge memo, my lord. Here, below, in first two paragraphs, below, second paragraph, whereas he was released on bail on 17/12/16 on the
Page 48, my lord. Dated
7/3/2017.
My lord.
Yes, that's in the second paragraph.
yes, ma'am.
And the charge is page 50.
Hmm?
Charge is page 50. Your lordship has seen this charge. Because on the basis of which, my lord, the review was done.
He has submitted the written statement of defense
Well,
before the inquiry of.
submitted, my lord. Was
Yes.
In the first order, my lord,
So the tribunal has relied on this letter, and which other letter?
this is the only letter, my lord. This is the letter on which, my lord, thereafter the authority has acted upon since this was done, my lord, in page my lord, 43, my lord, release of pay and allowances of so and so, page for that is 8th July 2024, my lord, page 43, my lord. With reference to the above, the undersigned is directed to forward here with a copy of the so-and-so Group 1 of his department within the proposal for release of pay and allowances as per ROPA 19 has been approved in favor of so-and-so Excise Collector in Excise Directorate. He is requested to take necessary action in this regard. The follow-up actions has already been taken, my lord, thereafter, and ultimately, my lord, this has been done in 1/8/2024. And, my lord,
So these are the two communications which the tribunal has.
tribunal has only on the basis of this, my lord, tribunal has my lord, passed this order, my lord. Without going into the veracity of this matter, not only that, the charge sheet and other documents, my lord, which has been filed before the tribunal, my lord, tribunal has not gone into, my lord. I have shown to his lordship the charge sheet dated 2017, my lord. Initially, when this application was moved, my lord, the interim order was diffused. Interim order was diffused, subsequently direction was given, and in terms of that, my lord, process has been started. Now, my lord, my only submission is, my lord, when there is serious allegation has been made in this petition and not.
Where is the interim order? Which?
I just showed you. The interim order has not been granted, my lord. I just showed you that Justice Amit Talukdar's order. মার্ক করে রাখলাম কোথায় গেল? Justice Talukdar's order তো ছিল। My lord, in my supplementary affidavit, my lord, lordship will find, my lord, petition bench of this court, my lord, yes. Lord, at page 12, my lord,
Of the supplementary.
my lord.
This is an earlier writ petition.
My lord. And starts with page 4, my
So
lord.
that they don't proceed with the disciplinary inquiry during pendency of the criminal case. That was rejected.
In thereafter page 4, lordship, paragraph page 15, my lord, though divergent views has been expressed by the different branches of the Supreme Court from that, we do not find any reflection in the impugned order for consideration of the aforesaid facts and circumstances involved in the case in hand in the light of the aforesaid observations, though there is a lip service for consideration of the materials placed before it without disclosing the materials which were placed before the learned tribunal. Therefore, the above order requires our interference to consider the prayer of the petitioner for granting relief, final relief, in connection with the original application in the light of the observations made by us and above. Accordingly, the impugned order stands set aside, quashed. However, it is made clear that we have not expressed our opinion even on single point on its merit, and all points kept open before the learned tribunal to decide the same in the light of the observations made herein above. Since a considerable period has passed, we take care of expeditious disposal of the above matter by the learned tribunal by giving a direction to the affidavit opposition to be filed by so-and-so, and if any reply by so-and-so. Liberty is given to the parties to mention the matter before the tribunal for expeditious hearing after expiry of the aforesaid period. In the event such prayer is made, learned tribunal is directed to hear and dispose of the above original application without granting any unnecessary adjournments either to the parties expeditiously, preferably within period 8 weeks. Since it is submitted by Mr. Jayatosh Mujumdar, learned government pleader, on instruction in his usual fairness, as also to avoid any undue delay for the appropriate forum to proceed, that the respondent authority shall not proceed with the disciplinary proceedings till disposal of the above application. And, my lord, the tribunal, my lord, lordship has seen the tribunal's order, my lord, on the basis of those two documents, my lord, has, my lord, come to a conclusion that since the chief secretary has passed an order, so I will not apply my vicious mind or whatever and pass the order following that letter that I have shown.
And what is the impugned order before the tribunal? Charge memo. What is the subject matter of the OA? Where is the prayer in the OA?
Yes, sir.
Which page?
There is,
The
my lord.
interim order, my lord, page 70, my lord.
70. 70. No, we are asking where is the OA, relief in the OA.
OA starts from page 17, Milord.
Page 40. Yes.
Just in the prayers, Milord.
Yes, that's we thought so. He wants withdrawal of the entire departmental proceeding. That means charge memo. Because beyond charge memo at this point, nothing had happened. Charge memo is of 2017. And this OA was filed in 17 itself. Yes, that.
But this case was initiated, Milord, on the basis of a vague and indefinite charge. Kindly see page 50. It was on the first day when the matter was opened. Your Lordship asked my learned friend to show the charge on the basis of which they proceeded.
This has not been considered by the tribe.
My lord, yes, I will show your lordship. I will show your lordship because my learned friend only take your lordship's attention to the last portions of the.
No, we have gone through the entire order. Please show us
My lord, I will show you.
where vagueness of the charge has been
My lord,
considered.
charge is vague and indefinite. That was considered by the my lord learned tribunal. I will
Let's
show
see.
you. I will show your lordship.
Yes, come to that.
Kindly see the charge itself, my lord, whether it is sustainable or not.
No, that's not the issue. The tribunal correctness of the order by the tribunal is before us. Let us see
My lord.
that the tribunal has examined this.
First of all, may I place the charge, my lord?
Yes.
That the said Sandeep Kumar Rai, erstwhile Deputy Excise Collector of Canning so and so, undergoing police training. He was not in service at that moment. He was not holding any office at that time. Police training at SBSP Academy, Barakpur, was arrested from so and so on 26/11/2016 by the officials of so and so, West Bengal, under section so and so, while accepting bribe money of ₹1 lakh from a complainant for facilitating him to get required license for opening a bar complex. But where is the name of the complainant? Where the bribe money was accepted? And my lord, what was the purpose for which the my lord the license was it was my lord alleged to have been facilitated? Nothing is there. Even in the next my lord imputation of charge, there must be some disclosure. Here also your lordship would found that there is also no disclosure of any particulars, my lord, because charge is to be specific and charge is to be, my lord, in order to answer the charges, my lord, they must, my lord, project what are the allegations that they have not disclosed in the charge memo, my lord. Then, my lord, annexure 3, kindly see, 2 documents they relied upon, memo number so and so and memo number so and so. Those were not provided because in the way your lordship found that a copy of the memo was not supplied, that was one of the prayer. Thereafter, your lordship, kindly see, from the charge memo, your lordship would not found even No details and no violation. No details, no violation of any rules and regulations for which he was asked to be proceeded departmentally.
Yes.
Thereafter, my lord, I file an application before the, my lord, the inquiry officer, that I may be provided with legal assistance. And, my lord, since on the same charge, a criminal proceeding is continuing, so, my lord, the departmental proceeding should be stayed. Both two prayers were rejected by the Honorable Tribunal. And thereafter, we challenge that order of the tribunal in a WPST, my lord, that is page, my lord, it starts from page 74, where, my lord,
Why do the same document have to be placed again? We have just seen the order. You were here right now.
my
Why it has to be placed
my
again?
lord, I have to submit my own case, my lord.
But the same document we have
because-
seen, it
yes,
has,
my
we have
lord,
already seen that
There-
the
there-
High Court recorded the stand of the State
my lord,
Council that we will not proceed during pendency of the matter
my
before
lord,
the.
there, what happened, what I am to draw your lordship's attention,
Yes,
that is to be taken into consideration,
yes,
because it was filed, the challenge was in 2017.
correct.
In 2017, the Honorable Division Bench made a, my lord, direction that the matter to be disposed of as expeditiously as possible
Yes.
within a period of 8 weeks. My lord, it was in 17.
Yes.
And it was not done. They have not taken any step. They sat tight over the matter.
Yes.
For 17 to 2013. So, my lord, that is totally barred by limitation by dint of the court's order. Because,
Limitation.
my lord, if an order was passed by the highest court of the state, my lord,
Yes.
and that was not carried out by the, my lord, the department,
All right.
that 8 weeks time was preemptorily given to, my lord,
Preemptively, that it will stand up, the proceeding will stand.
my lord, that I am not saying. I am saying, my
Preemptively,
lord,
you are saying.
it should be given honor, because here in this way application, my lord,
Yes, expeditiously and preferably. This is
preferably
the
within
expression.
eight
This is the
weeks.
expression used by.
My lord, 8 weeks.
And you have never gone to the High Court for contempt.
No, my lord, I have not gone for a
Therefore,
contempt.
Then,
It is incumbent upon them, my lord,
all right.
for the interest of their departmental proceeding,
Yes.
that they have to take step properly.
Yes.
My lord, here what happened, my lord, in spite of the direction of the Honorable Division Bench, they have not filed any, my lord, reply to the allegations made by us. Even they have not filed any reply to the supplementary affidavit we relied upon. So, my lord, they have not challenged the contentions of the petitioners which we have made in the, my lord, original applications by filing the reply. Thereafter, my lord, after so many years in 2023, the matter came up for hearing and it was heard. Now I will show you, lordships, from the order of the Honorable Court. And before that, my learned friend says that only on the basis of the, my lord, the order of the Chief Secretary, for 2 letters, 2 documents, my lord, the Honorable Tribunal has quashed and set aside the, my lord, departmental proceeding. And he was given the benefit. But that was not the case. If your lordship kindly see the voluminous documents of, my lord, the supplementary affidavit, which was relied upon on the basis of, my lord, the documents available subsequently, and those were, my lord, placed before the Honorable Tribunal, my lord, to adjudicate the matter. And there, my lord, what we have, my lord, annexed in that original, in that supplementary affidavit, my lord, that if your lordship kindly see that the day on 25th and 26th of, my lord, the date of occurrence when the complaint was lodged. My lord, the documents were produced on the basis of RTI that on 26th it was closed. The SCB office was closed.
We are not considering the allegations.
No,
That is-
Milord,
that is
I am
beyond
not
the
saying,
scope, but
my lord,
that is beyond the scope of.
I am not saying, my lord,
Let
the
us come back.
documents which we relied upon, what my learned friend said.
First, show from the tribunal's order
Fine.
what the tribunal has considered.
Fine,
We will not go through 50 documents and then find that tribunal has relied on
Lord.
only 2 documents.
No.
So first show us which document the tribunal has relied
My
upon.
lord, I am grateful.
Then you
Lord.
come to the document and show
I
us
bow down before
how
you,
it
Lord.
sustains the tribunal's order.
I bow down before you, lordship. The matter is taken up by learned single bench pursuant to the order obtained contained in notification number so and so. In the instant case, a departmental proceeding was initiated against the applicant for commission of an alleged offence of taking bribe from one Swastik Nag, a director of Traffic Entertainment Private Limited, for obtaining one Barkam restaurant license.
Come to page 4 in the light of available material. From there, the tribunal's conclusion starts. What has it relied upon? Let us see.
My lord, page 241. In the
Page-
light of available materials and records as well as the supplementary affidavit,
Yes.
the tribunal beyond any reasonable doubt has come to this conclusion that the allegation against the applicant is untenable.
Yes.
The very fact of the applicant's posting outside jurisdiction of North 24 Parganas defies any logic for such allegation. The Honorable Supreme Court of India in P. Vijay Kumar versus State of Tamil Nadu had observed that recovery of currency notes for illegal gratification without proof of demand is not sufficient under Section 7. In this case, both the post-trap memorandum prepared by ACP as well as the report of the Special Public Prosecutor in charge have denied recovery of the said bribe money from the physical possession of the applicant. Such recovery from elsewhere in the case of from the sofa where the complainant himself was sitting cannot be regarded as being recovered from the applicant. Additionally, the closure of the ACP office and non-appearance of the complainant there on that day to lodge the complaint on 26/11/2016 completely negates the statement recorded in the FIR. Statement in the RTI copy of the Joint Commissioner of Kolkata Police Administration on 14/7/2017. Assistant Engineer PWD Kolkata West Subdivision 2 on 27/2017. And the report of Special Public Prosecutor in charge of the case submitted to the learned legal remembrancer dated 21/11/2017 are clear pointers. These reports pose a big question mark on the authenticity of the entire trap episode, and intention to malign the applicant cannot be ruled out. Notwithstanding the direction of the Honorable Court in 2017 for concluding within 8 weeks, continuation of this inquiry is absolutely unjust. Justice delayed is justice denied. It is pertinent and necessary to cite the relevant judgment of the Honorable Supreme Court in Premnath Bali versus Eastern High Court of Delhi recorded in 2015-16 SCC. Keeping these factors in mind, we are of the considered opinion that every employer, whether state or private, must make a sincere endeavor to conclude the departmental inquiry proceedings once initiated against the delinquent employee within reasonable time by giving priority to such proceeding. And as far as possible, it should be concluded within 6 months as on outer limit. Where it is not possible for the employer to conclude due to certain unavoidable cases arising in the proceedings within time frame, then effort should be made to conclude within the reasonable extended period depending upon the case and the nature of inquiry, but not more than a year. That was the judgment relied upon. And my lord, before that, my lord.
Now please read. Proceed. Why are you stopping there?
No, my lord, I'm concluding. As such,
Yes.
the instant application is not tenable in the eye of law and is quashable and is quashed.
Which application?
My lord?
What is the application which is quashed? It says the instant application is not tenable. So what has been quashed? You tell us.
My lord, that should be corrected, my lord. It should
Corrected?
Be, my lord,
That is
not
what the
by
order
this
is.
court, my lord.
That's what the order is.
but
You have
your-
not sought any
But
clarification of this
your
order.
lordship pointed out, I'm really grateful to your lordship. As such, the instant
What has been
application,
quashed, sir? And why are you here?
my lord. My lord, the departmental proceeding, it should be there, and my lord,
You don't know
no, my lord.
how we can read
My
that
lord,
into the order.
from reading of these, my lord, from reading of these, my lord, it will be, my lord, found that the honorable tribunal, my lord, has taken into consideration the
Nothing, not even the date of charge memo has been mentioned
My
that
lord.
it is being quashed.
My lord,
What
kindly
has
see,
been
my lord,
quashed?
the charge memo, your lordship was asking me whether the tribunal has
Sir,
taken this
there are
point or
at least 10, 12 documents considered in the tribunal's order.
not. My lord.
So which one has been quashed? It says the application is not tenable and application is quashed. And that is the order you have taken from the tribunal. Therefore, we asked you that please read the last paragraph.
My lord, I'm grateful, my lord. This is my lord, the unfortunate thing which has happened, my lord. Then, my lord, what I pray, my lord, this should be remanded, my lord. Has to be. Has to be. Because otherwise it would be futile to argue before your lordship. Because this is a very, my lord, major lapses and rather.
It's not a lapse. The tribunal appears to have acted with some anxiety because it is pending.
My lord.
It has gone through every material as if it is the disciplinary authority.
My lord.
What kind of order has been passed, we don't know. It's to be said. But the fact remains that the finding is that the application is not tenable and it is quashed.
That is your lordship's reading, my lord, and I bow down before your lordship that this was not brought to our notice. And my lord, this is our failure, my lord, and also the failure of the my learned friend.
I have been, my lord, briefed later on, my lord. Someone is been in this matter. He left the brief. I was requested kindly appear in this matter. My lord. So I have come. Few days ago,
My lord,
this
but
brief was given.
this order was passed on the basis of the prayer on the in the way application, my lord.
There may be 100 pairs,
Yes,
but what
my
the
lord.
court finally allows
my-
that I need not tell you these things.
My
You know very well.
I should candidly submit before your lordship, and your lordship, if your lordship found that White Tribunal has, my lord, considered everything, if your lordship kindly come to page 221, the mandate for initiating any, my lord, investigation against a public servant to demean him before the eye of public, my lord, that unless PNR department, my lord, has given specific, assigned specifically, only in that case, my lord, the investigation can be initiated. So the lot of things.
Those were grounds which you were going to urge before the inquiry officer. Not considered by anyone directly, the tribunal is going into all
Yes,
this. How it can be, sir?
My lord, if the charge is vague,
No,
No,
that,
that is a different thing.
my lord, my
Charge-
learned friend has shown your lordship the charge sheet.
Charge vague,
That is
we
not
don't
the
know.
case before the.
If a charge is held to be vague, that is a different thing. But that's not the tribunal has gone into everything. It has attributed motives. It has attributed malefied.
My lord,
It has gone to examine as if it is
my lord,
hearing the departmental proceeding.
my lord,
Is that within the scope of the tribunal?
my lord, my lord, my lord,
Where is the finding that the charge memo is vague? Show us.
my-
We asked you earlier also.
my lord, it was argued by me, my lord, in page first.
Sir, we
That-
asked you where is the finding. We are not asking what you argued.
That the charge is vague,
We are not
ambiguous.
asking what you argued.
Fine,
Don't
fine,
unnecessarily make submissions.
Fine.
The review which has been granted. Hmm? Ah.
My lord, if your lordship, their submission also, my lord, in page 240,
Take
the
down.
charges against the applicant, my lord,
The
and my lord, one of the, my lord, Tribunal's Act. So, my lord, the documents which we have, my lord, received, my lord, under RTI, those are public documents, my lord. Those were placed before the Honorable Tribunal, and Honorable Tribunal, my lord, has considered those.
once you are conscious of the fact that it requires to be remanded,
My lord,
where is the question of
my
saying
lord, my
anything?
lord, my lord, I bow down, I bow down.
Heard the learned advocate for the parties. The
Guys, that I was talking in another court. Lorships, kindly do not be angry upon me. Lorships, may I just state, my lord, what has happened?
Which matter is this? We don't know. Oh, the morning matter.
My lord, kindly, Lorships, what
Yes.
happened was my senior, who usually appears, my lord, Lorships is most
All right.
aware.
What do you want? Yes.
My lord, I have got the copy of the decisions which were supposed to be here. My lord, the difficulty was this, my lord, since he has been brutally assaulted by
Now,
the police.
now we
my lord, I
understand.
had
So
to
what
be
do you
there.
want? Therefore, we are saying.
Now, my lord, your lordships had asked me to provide certain citations on that issue. My lord, I have got one Supreme Court decision of Syed Khadim Hussain, not which is pat on the point on my case that I was. My lord, he is at least for 2 months to 8 weeks bed rest has been
I had a talk with Mr. Rai. He will not be able to attend before
at
this
least
side
2
of the
weeks,
vacation.
8 months,
Before
my lord.
Before this side of the vacation. This side of the vacation.
May I beseech you to keep it, my lord,
No,
after 1 week after vacation. And my lord, I shall also come up prepared any further with the decisions and other things. I have got, my lord, but I. Yes, my lord.
We are.
Yes, my lord. My lord, I understand, lordships. I apologize. Grateful, my lord. Much obliged.
Number 106 and 107. I am appealing on behalf of.
There are two matters, my lord.
Item number 107.
The two writ petitions has been filed against one single order passed by the AFT, my lord.
So one is by the applicant and one is by. What has the AFT done? What has the AFT? You are in the first case.
Yes.
What the AFT has done?
AFT has granted disability pension by board bonding with effect from 2006 when he had been discharged from his service. And this, my lord?
You are representing the armed forces.
Yes. My lord, we need to challenge certain things where that when a particular method of payment is being made, some people are getting that particular method, my lord. And these are as per these are as no, these are as per the notifications, my lord. Well, in this particular case, my lord, there was no disability pension. For people who took voluntary retirement, voluntary discharge, compassion. Well,
Broad banding means
yes,
approximation.
Approximation, my lord. The percentage is it is enhanced, my lord. For somebody who is disability is between 30 to 50,
Will be taken as
32,
50.
he will be given 50.
So above 50 will be taken as hundreds.
There is another slab, my lord.
So it is basically a method of approximation.
Yes, my lord. That is not the issue, my lord. Issue is, my lord, when this person took voluntary retirement, my lord, that memo was not there. He went on fighting cases in Patna High Court, one after another. He even filed cases for reinstatement in service. Service benefits, my lord.
He was on which post?
He was a Sipai, my lord.
And he took voluntary retirement on?
31st May 2006, my lord.
31st? 2006. So on that day, what benefits he was getting?
Because he no retirement benefit. He was not going to be
Completed the service.
Completed the statutory period of service, my lord.
Oh, so he did not have qualifying service. He was not entitled to anything, according to you.
Yes, sir.
Then what happened? What did he do?
Then, my lord, he went up, my lord.
Sorry,
petition.
before that, what is the qualifying period? 10 years?
10 years, for 15 years, 15 years.
15 years. Yes. So then what happened?
Then he went up before the Patna High Court, my lord.
Yes.
He filed a writ petition 18/4/2009, writ petition dismissed.
Yes.
Again,
what did he file a writ petition for?
This one was possibly for reinstatement, my lord.
Reinstatement?
63, page 63, my lord. He was same qualifying period, my lord. Kindly see page 63.
Must have directed for representing.
The party that is accordingly dismissed.
Yes.
Then, my lord, next page 65, another writ petition. Retiral dues.
Yes.
Then, my lord, in 2009, he filed a writ petition.
Yes.
That was disposed of subsequently. In the meantime, 29/9/2009, my lord, new policy was published.
So these are the only two writ petitions he moved before the
Three writ petition. Another has been disposed of on in 2011.
Where is that?
9th May 2011.
Where is that one? That was pursuant to the liberty granted in the second writ.
Possible. That has possibly not been annexed to. 101, my lord, 101, page 101. The effective 121, my lord.
Yes.
Then, Malli, kindly let's see whether what the number page है. Policy 29/9.
So after that,
After the in the meantime, my lord, 29/9 new policy was published by the government of India for grant of disability entitlement to armed forces.
what is the date?
29th September 2009.
All right.
My lord,
Yes.
the petitioner was there thereafter on 9th July 2020, 2010. The respondent granted 30% disability.
9 July 2010.
Right. After that, in 2012, his representation for
Enhancing.
enhancing and arrears was
This
rejected.
9/7/2010 order, where is it?
9/7, Nischay.
Granting the disability pension.
Page 68 is the PPO, my lord.
Order. 9/7/2010 is the PPO.
Is that page?
68, my lord.
68.
Yes, my lord.
Type copy is 68A. my lord. Next.
A. Where is the percentage recorded? All right, at the bottom. Asthmatic bronchitis aggravated 30% for life. That's the last line, yes.
Very last line.
After, now in 12, he came up with a request that it has to be enhanced.
Yes, but this has been disposed of at page 73 on 16th January 2012. He had made several.
No, where is his request?
10th, 22nd March, he had made one request, 16th September, 29th November, 30th March.
So this disposes of more than one representation.
Yes. Well, can you see page 73? So he is asking for service, service, element of disability pension as well as broadband. এইটা ওরা পরে পাবে তো এখন তো পাবে 2010-এর পর থেকে তো পাবে এই 16।
Yes. This is the impugned order before the.
Yes, ma'am. কিন্তু এটা অর্ডার এত 10 বছর এটাই ইমপ্লিমেন্ট অর্ডার। আচ্ছা, yes, madam. This is the impugned
Before the FT.
AFT, madam.
16/1/2012.
Yes, madam. 16/1/12 is challenged in 2009. It is challenged in 2019. It was disposed of on May.
So by January.
Amar.
On page 42, my lord, the impugned order has been stated. Paragraph 1 of the original application.
Order is
16th January 2012, my lord letter.
So this is the impugned order.
Yes.
Undoubtedly.
And what the FT has done?
AFT Miller had 3 issues, Miller. And AFT order is at page 25.
Yes.
Formulated 3 issues at page 29, Miller.
So only the broadbanding has been allowed. Service element has not been allowed.
No, service element has
So
not.
he wants service element and you say nothing beyond 30.
Yes, Miller. The service element is his second application. He has challenged.
So therefore he wants service element and you say nothing beyond 30.
Yes.
30.
Yes, well, in our appeal, yes, with nothing beyond 30. No, nothing beyond 30 is also subject to a period, Miller.
Yes.
Unfortunately, our reliance was one judgments of 2 Supreme Court. One is Tarsem Singh and is Sivdas. Both have held. When you file the petition, you are entitled to claims even in retirement benefits, Miller. You are entitled to benefits 3 years. And
come to the order 9/7/2010 at page 68. And please read column 13 of page 68.
Yes, well, it does say from one.
Because 31.5 he has taken VRS, you say from 1/6 for life. Therefore, there is no issue that way. That is apparent from your order itself. So it is only that you say nothing more than 30%.
No, also areas have been challenged, my lord. Areas have been
How
challenged.
can you just see the order that you have passed? Disability elements sanctioned per month from 1/6/2006 to for life. Therefore, there is no occasion for you to challenge this. And we don't know why you have not paid it. Once you have sanctioned it like that, why you should not pay it?
Well, he is getting disability element at 30%, my lord, from 1/1/2006.
He has got it
He is receiving.
from 1/6.
Yes, my lord, he is receiving. What has been denied is
Denied
the
is
broadband.
rounding off, my lord.
That is
Therefore,
30.
that's why we said nothing beyond 30.
Yes.
You are not willing to give anything beyond 30 because you say it is
Because
not
that
sustainable.
policy came subsequently.
So it is not sustainable according to you.
Yes.
And the tribunal has said to round it off.
Hmm.
Now, what is the infirmity in this decision? Let us see how you say beyond 30 he cannot get anything.
Well, because the policy came subsequently, my lord. The policy টা দেখো কত পেজে আছে policy 2000 তুমি আমাকে
So you are banking on the same policy 29/9/2009.
no subsequent when rounding off was started, my lord.
So that came even later.
Later.
When is that? Where is that?
Print করেছো তো?
Lord, that came up in terms of the recommendations of the 6th Central Pay Commission, my lord. So, my lord, the
Page
issue concerned
120.
is from which date the arrears shall be given, my lord. So, my lord, my learned friend, what my learned friend agitates is, my lord, it should be restricted to 3 years prior to date of filing the original application.
That
I
Supreme Court has said,
supposedly
but
his
that is
point, my
one of my arguments, my lord.
No, what does the policy provide? Let us see.
That is at page 122.
122.
The writ
What is the date?
Well, this is 9 February 2018. Previous to this broadbanding was not given to people who had proper data. বলো? হুম? প্রিন্ট আউট করেছে তো আছে তো এখানে নেই আছে না थर्ड जनवरी से কি ছিল ওদেরকে ছিল না যারা ভলান্টারি রিটায়ারমেন্ট করেছে তাদের ছিল না হুম এই যে লাস্টে provisions of GOI 23rd shall take effect from 2000 annex করান এটা নেই ওখানে এইটা তো বললাম এটা কত আছে 122
So this, this policy contemplates grant of the benefit with effect from 1/1/2016.
Broadband.
And when the tribunal has allowed it with effect from
2006.
Date of retirement.
Yes.
That's what. Well,
Yes.
Well, these issue, whether the broadbanding element from which date it will be given, was already settled by AFT as well as the Honorable Supreme Court way back in 2016, my lord. My lord, and what my learned-
2016.
Yes,
so
my
I will show one.
He is saying broadbanding has come into force from 2018. Then how it can be settled
No,
into the
I am strongly denying, my lord. It came with effect from 31st of January 2001, my lord, with the recommendations of the 6th pay commission. my lord.
broadbanding?
No. Previously, broadbanding was limited to people who have retired, my lord. It was not available to those
Voluntary.
people who had voluntarily retired, my lord. It was not.
Voluntary retirement for the first time it has
This,
come.
yes, my lord. Subsequently, this was
No, my
made
lord,
applicable to them.
Date
Here it
concerned-
is retired, discharged voluntarily.
Yes.
Both.
Yes. Let discharge voluntarily. Madam. Now, my lord, the issue has been settled by the Honorable Supreme Court by the Honorable 3 judges bench, my lord, on 20th September 2016.
Yes.
My lord, upon going through the writ petition, my lord, I find that a new order, my lord, of stay, that is an interim order that my learned friend has relied on, that is stay granted in a similar issue where relief has been granted by the AFT principal bench for since
I
date of
should have
retirement, my lord.
That means the matter is
Well,
pending. The ASG has given undertaking to release all dues 3 years before.
My lord,
3 years.
3 years before that application.
that is a
The date of filing of the OA.
Yes. 126. Page 126.
So have you already granted him this?
Well, this has been granted. That is not under dispute.
No, my lord,
This
But-
element is not under dispute.
that is an interim order passed
Correct.
by a two judges bench.
So if they have complied with that, then can we determine the issue before the apex court?
Already determined by a larger bench, my lord, fully determined.
This case.
These issues, my lord,
Issues-
this issue concern.
No, I don't know why the larger this judgment was.
It is a completely decided issue, my lord, by a 3 judges bench, my lord. It is restricting the areas to 3 years only in regard to broadbanding. May I read out, my lord?
What is the date of this order that you are giving?
My lord, the last page, my lord, 20th of September 2016.
But this is prior to.
Yes, prior to this order.
Yes. Yes.
Yes, my lord, on the basis of
This has been considered by the tribunal.
Yes, my lord. On the basis of this, my lord, the tribunals all across India has been granting the relief of broadbanding only, my lord, not the disability element. Where disability element they are getting, only broadbanding is considered, my lord. The areas of broadbanding is given with effect from 1/1/1996 or from, my lord, the date of retirement, whichsoever is later, my lord. Well, prior to 1/1/96, no question. Only the broadbanding, my lord. Here, my lord, the person is getting disability element with effect from 1st of June to the 1996, my lord. So it has been granted by the tribunal with effect from the date of his retirement, my lord. On the basis of this very order. This issue has been settled.
This order does not possibly pertain to a person who has falls under the voluntary retirement scheme.
That's not the issue. Issue is from what date he is to get the rounding off.
Because he was not entitled to. Subsequently, memo came and gave him that entitlement. He got the right from a particular right. He is not challenging that memo, which has fixed his right with effect from 2016.
1/1/2016.
He has not challenged that.
When the issue is already settled, my lord.
Mhm.
The issue is already
It's a bit
settled by the
different,
honorable.
my lord. That is
No, no, my
possibly why this.
First condition is, my lord, that disability pension that person has to get, disability element, my lord. No doubt, my lord, he has been granted, given disability element, my lord, with effect from the date next to the date of his retirement, my lord. That is there, PPO is there. Once PPO is there, my lord, he is getting disability element. The question arises whether he will be entitled to get the broadbanding. If he is entitled, then with effect from which date, my lord? Had he retired prior to 1/1/1996, my lord, he could have got it from 1/1/1996.
This petitioner before the apex court in this judgment, he was getting the broadbanding.
Yes, my lord, everyone.
The basis of which decision?
Well, this was in regard to the order passed by AFT Chandigarh bench, my lord, OA 1289 of 2011, my lord.
888, Supreme Court. This one.
My lord, the similar issues are being re-agitated by the Union of India time and again, my lord. And now, my lord, what my learned friend came up with, a stay granted by the
No,
two
there
judges
must be
bench,
some
my lord.
reason. The Supreme Court, we cannot presume that Supreme Court will has chosen to look into it in spite of all these orders being placed.
Anyways,
before it.
my
There
lord, that
must
is
be
an
right.
interim order and cannot be relied on. This is a final order, my lord.
So two things we are required to see. You come to page 2 of the Supreme Court order. There the petitioners were retirees. That's one thing that has been noted by the apex court. And they are getting, they are retirees prior to 1/1/96. And benefit of rounding off of disability was being done as per letter of 31/1/2001. Where is that 31/1/2000?
The voluminous letter, my lord, by the
No,
government.
you are claiming parity with them. So therefore we are asking you, what does it say? That all who are getting now, they will get it from the date of their return?
That is the actual letter whereby the recommendations of the 6 cities.
Sir, you want this benefit. So you have to show that you are at parity with the writ petitioner or the person who was before the apex court.
Yes.
Either you show it or we may proceed that you are unable to show.
No, my lord, I shall so, my lord, that is not annexed in either of the writ
That
petitions.
cannot be. You are relying on it. You should have come forward with it.
My lord, I should have come forward.
That cannot
My lord,
form part
no,
of
no,
the
one
record.
thing is undisputed, my lord, broadbanding only we shall be entitled only when I am already getting the disability element, and
We
that
don't
is not
know.
denied.
That's what we are trying to. It may be clear to you. We want to be clear also.
My lord, that will be also available, my lord, from the pension regulations also, my lord.
So show it. Which is the relevant?
Bill 2006.
Well, kindly fix another date and then.
I shall come up, my lord, with the, because this is 1961 pension regulations will be required, my lord.
The writ petitioner, the Slightly delayed, actually, one constable outside the chamber, he collapsed. So we were trying to get him to the ambulance. That's why we got detained.
There he has got.
No, now he has finally left. So sorry for the delay. Yes. Yes.
Original set, item number 1.
Item number 1, my lord, I appear for the respondent WBIDC. My lord, in fact, WBIDC is the only respondent. I have already made my submissions. My senior friend was giving reply to my submissions. Only one point which I wish to point out to your lordship, if your lordship kindly takes up, my lord, without much ado, and I won't waste your lordship's time. My lord, if your lordship kindly takes up the stay application. My lord, all along my endeavor before your lordship was with regard to the maintainability of the writ petition, because the fact with regard to charging of transfer fees was very much there before the NCLT. I pointed to your lordship. The NCLT had not, my lord, in fact, approved the entire resolution plan. They challenged it because with regard to other charges, statutory liabilities, fees, etc., they challenged it before the NCLAT. NCLAT dismissed their application. They went up before the Honorable Supreme Court, raised the same point. My lord, the Supreme Court has dismissed their SLP. So, in fact, when the writ petition itself was not maintainable, the Honorable Single Judge was pleased to dismiss the writ petition on the ground of maintainability, but went ahead to deal with the merits also. But when it is dismissed on at the threshold, my lord, nothing remains to be adjudicated. That was my humble submission. Now, my lord, if your lordship kindly takes up volume 4 of the stay application.
Which page?
My lord, page 431. This was the correspondence which was lastly relied upon by my lord senior friend. Page 431, the letter dated 6th July 2022. Written by us, written by the WBIDC. Has your lordship got that, my lord?
Yes,
431. My lord, in fact, my learned friend, my lord, subject to correction, was relying upon the page 433, the penultimate page of that particular correspondence. Your lordship possibly has marked that also, my lord. Page 433. Has your lordship got that, my lord?
Yes.
433. The first paragraph was being placed before your lordship. It is also an admitted position that pursuant to the resolution plan, the entire shareholding of the corporate debtor shall now be taken over by the resolution applicant. Moreover, in view of the resolution plan being approved, pursuant to the orders mentioned herein before, the existing board of directors has been replaced by a new board of directors comprising of your members and your representatives. It is denied that transfer of shareholding of the lessee company cannot be termed as transfer of lease, unless the lease deed expressly makes such specific inclusion that change in control will be considered as a dream transfer as alleged or at all. Then, my lord, I will not trouble your lordship. The next paragraph he has laid emphasis upon. My lord, this particular letter with regard to transfer fees was issued by the WBIDC, the 6th July 2022 letter, in reply to the letter which is appearing at page 424 of the petition of the appellant. Page 424. When they were reiterating the same point with regard to transfer fees. Has the lordship got that, my lord? Page 424, the letter dated 20th May 2022. If your lordship kindly takes 431, there it is written, my lord, reply to the letter dated May 20, 2022. So transfer fees was dealt with. But if your lordship kindly sees what is there at page 424,
yes.
my lord, compliance with the order of the Supreme Court, the head note, the subject. Compliance with the order of the Supreme Court dated 4th May 2021 is civil appeal number 1142. This is what they were seeking of. The Supreme Court had dismissed their prayers. Now, if your lordship kindly turns to page 426, I will not trouble your lordship with the entire contents of that particular correspondence. Page 426, on and from, my lord, paragraph 7. A perusal of the above order makes it evident that the Honorable Supreme Court has upheld the original resolution plan as submitted and approved by the COC as a whole, except for a minor aspect pertaining to the security expenses of WBITC only, and hence mandatory clause 15.15.5, which permits waiver of transfer fee unconditionally if arises, should be accepted and honored. My lord, clause 15.15.5, I pointed to your lordship, was not approved up to the Honorable Supreme Court. This is clear that Supreme Court approved the resolution plan approved by COC in totality, while only directing inclusion of payment of security expenses. Next, my lord, therefore the resolution plan as a whole was approved by the Supreme Court, while only directing the inclusion of security expenses of WBIDC without any further
So
modification.
this 15.15.5 is at which page?
Clause 15.15.5, your lordship will get it at pages 208 and 209, which will be volume 2. Volume 2 बताएगा. हाँ.
197.
Yes. So this was not approved.
This was not approved. If your lordship kindly, my lord, I have shown that order of the learned LCLT at pages, which starts from page 239 up to goes up to page 309, paragraph 67 and 68. Your lordship has possibly marked that. Paragraph 67 and 68 at pages 296 and 297. Lord, had the entire plan been approved, there was no necessity for them to approach the learned NCLT and thereafter the Honorable Supreme Court. In fact, that particular waiver clause was not at all approved, and it is evident from paragraph 67 and 68.
Not approved, that you are saying, because paragraph 67.
I'm grateful to your lordship. Lord, this is my submission, madam, because I've already, my lord,
But paragraph 67, does it close the issue?
it closes the issue, my lord, and for that, my lord, that is what I was submitting. For that reason, my lord, they went up before the Honorable Supreme Court, up to the Honorable Supreme Court.
Can
Then
you-
it NCLAT also.
You read the last 3 lines at page 296.
296. But any exemption for payment would be dealt with by the respective authorities applied for. But that is there.
So therefore, we asked you whether it closed the issue or it left it to be agitated.
Well, that is why, my lord, I relied upon issue estoppel, because the same point with regard to, my lord, your lordship may kindly recall.
Yes, we remember. Therefore, we are
The
asking.
point was raised before the Honorable Supreme Court also. Why should I go before the authority seeking exemption? And the Honorable Supreme Court declined to interfere in that particular.
All right.
I'm grateful to your lordship.
But Mr. Banerjee would like to make submissions. He's
We
for another.
we
I
have
understand,
kept-
my lord.
For him only today it was.
So I understand, my lord. He's suddenly something came up. He's for another division bench, my lord. I was only praying if your lordship can accommodate us any other day if tomorrow or some other day, my lord. It won't take more than 5 minutes, my lord. We assure your lordship on that.
You are very secure.
Twenty-nine is not.
এটা বাজে।
My lord, Monday. Very well. My lord, any day, Tuesday then?
Any day.
Tuesday. Wednesday, Thursday, হবে দেখি। No, if it বুধবার হবে তো? বুধবার।
Next one.
Very well, Thursday. my lord.
On a Thursday week, my lord, your lordship. But tomorrow,
That's
4th September.
Thursday. I'm grateful.
Lord, can it be Wednesday? 4th again, Mr. Banerjee is. I understand. I don't know what to do, Lord. I'm also in a predicament, Lord. Very well, Monday week.
Monday week. Lordship, may kindly record, my lord, I've already concluded my submission.
So great.
Appellate side 2 p.m. fixed matter, item number 187.
Petition ওইদিকে। কে কোথায়?
But in this matter, I am appearing of Public Service Commission, Lordship.
Clear কোথায়? আমার clear কোথায়? না?
You have seen the last order. You have seen our last order.
But BSc is there because whether chemistry is a compulsory subject according to.
You have seen our last order. Why? Show him.
স্পেসিফিক কোশ্চেন করেছিল যে ল্যাটারাল এন্ট্রি আর রেগুলার তুমি আলাদা বলেছিলে, সেটা এক না আলাদা?
He will not be guided by your perspective.
No, well, I have gone through my last order.
Let him read.
No, but immediately on the next day.
পরে থার্ড পেজে যাও,
See, on the last day we had taken notice of the fact that the diploma entitles him to exemption from 1 year in the BTech. In that 1 year, he is supposed to study chemistry. Now, since you have found the diploma worthy of granting of an exemption from chemistry, and he has got the BTech degree, does your policy contemplate two kinds of BTech degree? It is not your case that he does not have the BTech degree.
No, he has got the BTech degree.
So,
That's no dispute.
does the state give two kinds of BTech degree?
My lord, kindly turn to page 124 of the.
He has to respond. You please wait.
Page 124, what can I see? In connection with the above subject order, the undersigned has to close the government order number 30th September, which reveals that lateral entry Theo Diploma Engineering course is equivalent to general entry BTech degree. This is equivalent to BTech degree.
No, there is no question of equivalent. He has a BTech degree.
Yes, he has got a BTech degree.
There is a question of equivalent. Equivalent will arise if he does not have a BTech degree.
Yeah, but whether chemistry is a compulsory subject, that he does not have a chemistry while passing the BTech degree. Only that question. And under advertisement, he said that he must be an essential qualification science graduate from recognized university with chemistry, physics, and mathematics. Man, kindly see the advertisement.
Come to page 57. Based on this, you have given him exemption from the first year.
Yeah, chemistry 1, 50 full marks.
Yes.
But normally in BSc chemistry, 100 marks.
Hmm?
In BSc, Calcutta University, Border University, and Northern University, other university, BSc must have chemistry with 100 marks. Here is a chemistry 50 marks. Chemistry and 58.
There must be a chemistry 2 also. It says chemistry 1.
50 plus 50.
So there must be a chemistry 2 also.
Chemistry 2 also.
Chemistry 2 is on the next page.
Page 58.
So it is 100 marks. 50
100.
plus 50 is 100. How the state can say that BTech is of two kinds?
It has been decided by the PSC. PSC can give the answer.
The PSC does not specify the qualification.
No.
Qualification is sent by you.
Qualification, rules framed by the state government and vacancy notified to the PSC. PSC advertised the post.
Yes.
They made the selection and they rejected his application.
No, but the requisition is sent by you in terms of the rule.
Rules.
So if the rule specifies a particular qualification, you must have communicated it to the PSC.
Yes.
So where is that? What is your stand? Does the state say that there are two kinds of BTech degree being given by the state?
Kindly see the reply filed before the page 86. Only reply filed by the Public Service Commission.
One?
Only one, 86.
No, so What is the rule? What is the prescription in the rule? Please show us.
Rule has not been annexed.
That has to prevail.
Yes.
You must have sent your request. You have the rules.
Yes, my lord. On that day, I handed over. My lord was pleased to return me, my lord, as and when occasion arises.
অত বড় কি দেখে
রুলটা দিলাম, পুরো রুলটা। And we turn to page F123. The pagination is at bottom. Near the fag end, my lord.
Oh. Right. Rules relating to recruitment.
Recruitment of sub-officer.
Sub-officer.
Posting question is, my lord, sub-officer. Sub-officer. Then your lords will kindly turn to next page. My lord, from the bottom. Qualifications, direct recruitment, essential. Then, my lord, next page, my lord. Diploma in civil, mechanical, electrical, automobile, or hydraulic engineering from the State Council of Engineering and Technical Education of Government of West Bengal or equivalent qualification.
Which page?
Page, my lord, F128, the next, very next page.
128.
Yes, very next page. Top.
It is important notification.
Oh, I'm sorry, my lord, page, sorry, 124. 124, I stand corrected, my lord. I beg to
24.
124, the very next page, my lord. Very next page.
124, 124.
Top, my lord.
Yes.
Top. Diploma in civil, mechanical, electrical, automobile, or hydraulic engineering. From the State Council of Engineering and Technical Education. My lord, I am qualified in terms
No,
of
3-1 is the same.
1 is the same, my lord. It's the rule, my lord. And one continues with this, my lord. Even the Bengali advertisement which I have, my lord, annexed in the read petition at page 72, that also speaks of this. It's a Bengali document. My lord was pleased to ask me to produce the original, my lord. I have produced.
You have got you have given us the translation.
No, not translation. It's the original, my lord, from the archive, my lord. I have got it. The Bengali transcription is there, my lord. Wherever, my lord, any sort of education, this sort of.
Or its equivalent. Here it says or its equivalent.
Yes.
So how do you reconcile the two? You just see. The rule says BSc with physics, chemistry, and mathematics, or that is you have omitted in the advertisement. You have omitted this entire thing from the advertisement. It is there in the rule. Diploma in civil, mechanical, electrical.
Advertisement was published by the PSC, not by the state government.
So this rule, there is no ambiguity that this is the rule under which it has been.
Yes. Rule has to be followed.
No, this is the rule under which it is being done.
Yes.
There is no subsequent rule.
No.
The rule was forwarded to the PSC along with the requisition to advertise the post. And selection was made by.
My lord, my lord, may I submit one thing? My lord, can
Yes.
you turn to page 72 where the Bengali version of the advertisement is annexed? My lord, in the advertisement, it is written in Bengali that স্বীকৃত বিশ্ববিদ্যালয় থেকে ফিজিক্স কেমিস্ট্রি অ্যান্ড ম্যাথামেটিক্স নিয়ে বিজ্ঞান শাখায় ডিগ্রি কোর্স পাস বা সমতুল্য my lord, the সমতুল্য means that or its equivalent.
No, it's actually that is what you are saying is apparent from the advertisement which has been produced by the learned advocate for the petitioner. It also says or its equivalent.
Or its equivalent.
But the rule does not say equivalent. The rule says or diploma also. Rule says diploma in civil, mechanical, electrical, automobile, or hydraulic engineering from the State Council of Engineering and Technical Education, Government of West Bengal, or equivalent qualifications. So this insistence on chemistry, which is being made by the PSC,
Yes, Lordship.
how you are sustaining this insistence, that is what we are trying to ascertain. Because one is a degree in science with physics so and so, that means BSc degree, obviously.
Yes.
Physics,
Yes.
chemistry, biology, normally mathematics, physics and chemistry in a normal BSc in all universities. Pure science.
Normal piece.
Normal all universities.
Pure science, bioscience.
No, bioscience is different.
Different. তোমার
না কেমিস্ট্রি বায়োলজি আর একটা কি যেন একটা জিও সায়েন্স
না physics, chemistry, biology.
No, this is asking for physics, chemistry, mathematics. Biology is a separate stream.
Yes, man. I'm just trying to make him understand that there in BSc there are two types of.
Correct. So one is with the biology.
One is
bioscience. It's called bioscience.
One is bioscience. One is pure science.
Pure science.
Degree from recognized university with physics, chemistry.
So
and
are
mathematics.
all the posts filled up?
No, one post has been kept vacant, my lord.
There is an interim order.
Yes, interim order. My lord, it was before the learned tribunal also, as well as before this honorable court also.
And
Today,
selection of
when the matter is
2016.
taken up,
Number 108. Item 108.
No one is there. এই 108 107 যেটা হচ্ছে 108 108
Mr. Robiul Islam is appearing on behalf of the appellant, my lord. I'm praying for an adjournment for a day, my lord. My lord, he's currently engaged before the Honorable Division Bench, my lord.
The learned that
Fine.
probably about everything.
AFT.
EFT, my lord.
So we asked the learned advocate in the morning also. You have any data of how many orders you don't challenge?
My lord, in this context, my lord, may I submit one document?
Yeah.
Very recently, my lord, I got this, my lord. I don't know whether it is.
Yes, what is it? What is?
Well, actually, just my lord, I only have 2 copies, my lord. That is they mentioned now, lordship, that is the officiating Cornell PS4 said that
Now there is a litigation policy.
my lord, yes, my lord. They said
That is
now
a very
where the
good-
case.
So which one applies in this case?
My lord, here the disabilities assessed NANA by initial categorization medical board and successive categorization medical board followed by similar assessment by RMB, IMB, and not accepted by the adjudication authority.
And accepted by.
And accepted. I know, my lord. I am very. I mean, my lord, I only have the 2 copies, my lord. I am tendering my apology, my lord. আমার ল্যাপটপে আছে ব্যাগে আছে ব্যাগে ব্যাগ
So this is covered by which?
My
B,
lord.
C or D?
My lord. My lord.
Which one?
But actually, I
Here,
don't.
have a look.
And I'm.
We'll go through one.
My lord, the initial, my lord, my disability has been assessed NANA at the 20%.
At the initial level.
No, my lord, at the
By the RMB, what was the assessment?
by the RMB.
What was the
My
assessment?
lord, they're neither attributable to nor aggravated by military.
It was a NANA case.
My it is a NANA case, my lord.
Then
I am
what happened?
totally. Therefore, my lord, I claimed prayed for my disability pension. My lord, they rejected only on this ground, not applicable because it is a NANA case, neither attributable nor aggravated. Why not attributable? Why it is not aggravated by military service? My lord, these reasons is always missing, my lord.
No, but then that will not be, the policy says, other than this, all other are being processed.
My lord.
This they will litigate.
My lord.
So if there is a finding at the RMB or at the initial stage,
my lord,
and that is subsequently turned over by the, what is the next authority?
First appeal and second appeal there.
Then they will not pursue the litigation. They
My
will
lord.
rely on the release medical board.
my lord,
But if at the initial stage there is a finding that it is not attributable and not aggravated, what you say, Nana,
my lord,
then their policy is that those matters they will pursue.
my lord, here, my lord, in my release medical board, my lord, they assessed my disability 20%. And neither attribute,
Oh, if there is a disability,
my lord,
but not aggravated and not attributable.
my lord. I am extremely আপনি আমার এত বাজে লাগছে না এটা তো আপনাদের ডকুমেন্ট আপনি আমাকে এটা আপনাদের ডকুমেন্ট আমি দিয়ে দিচ্ছি আপনাদের ইন্টারনাল ডকুমেন্ট
What is the RMB is release medical board?
my lord, RMB is release medical
What
board.
is IMB?
My lord, invalidate medical board, my lord.
So let us see.
My lord, another, my lord, RMB also referred as recategorization medical board, also lordship stands as RMB.
To take one this photocopy of this. Okay. So what the tribunal has done, why you are
Yes, my lord. Here is the my lord.
one case you should give us a compilation.
My lord, this is very good case. As per my no, my this is kindly a fit case for set aside. May I have one copy from my learned friend? What is
Well,
Please
today,
decide.
Mala, I have only one copy. But it is their documents, Mala. It is their documents.
Let us see the order.
Very well, my
What is the order? What has the tribunal held? Why?
Before going to my lord,
What is the ground on which it has been allowed?
my lord, I am submitting, my lord.
Devender Singh.
Not only the vendor Singh, my lord. There are 3-4 points which I will agitate before.
Dharamveer Singh, not Devender Singh. Dharamveer
Dharamveer Singh.
Ah.
There are 3-4 points I will agitate before Lordship. First point, my lord, Honorable Deputy Tribunal did not decide the case on the basis of question and law. Second point, my lord, a respondent didn't.
What is the date of RMB?
RMB date is, my lord, 9th September 2013. 9th September.
9/9/13.
9/9/13.
Where
There
is
was
the RMB?
inordinate delay, my lord.
Where is the RMB?
I'm submitting, my lord.
Let us see. That is the basic thing. Let us see what the RMB has.
Along with this, my lord, there are other things, my lord.
So let us see that first. That's
Page
where
30, my lord.
Page
30.
So he's entitled to service benefit or not?
He's getting the service pension, my lord.
So he has put in more than 15 years.
For more
20
than
years.
15 years. Right. My lord, there is relevant page number 32. Page number 32.
We'll get there. Don't worry.
Point number 5 and 12. And at the bottom, there is a signature of the respondent.
He was a sergeant.
Sergeant, my lord.
So diabetes.
Diabetes. There was a history of overweight.
So what has the tribunal? Now let us see the tribunal.
My lord, one thing, my lord. This
33
RMP has
page-
never been challenged before the FT.
Page 33 is the relevant finding. Yes.
This RMP has never been challenged.
All right.
On thereafter, my lord, page important, my lord, page 41.
Yes.
Page 41, rejection of disability pension claim. This also not been challenged, my lord. And there is a provision to file appeal, but they failed to prefer any appeal. And there was a delay in filing the original application, 5 years and 9 months.
What is the relief paid for in the OA?
Kindly see, my lord. Page number 68.
No, appeal has been filed in 2019.
After time barred, my lord. Kindly see, we have rejected, my lord. Kindly see page 112.
This was impugned before the tribunal.
They challenge this, not challenge the RMB, my lord. Not the.
No, this order has been passed during pendency of the matter.
No, no, my lord. Just a minute. OA filed after this order, my lord.
It does not appear so.
No, my lord. Kindly see 11th October 2019 and kindly see page 70. And there is a, at the bottom 27th number 2019, my lord. In the affidavit, my lord. Page 70.
But this has not been challenged.
Not challenged. No, एक second, 1 minute. 68. They challenge the first appeal only. Because the first appeal was not decided on merit, my lord. Because that was the time bar.
No. They say it should be considered on merits.
Merit.
No, they have not challenged. What kind of prayer he has made? That rejection has not been challenged. How such a prayer is being made to dispose of the first appeal when already it is disposed of? Anyway, we'll see. Yes. So this order was not brought on record before the tribunal.
No.
First appeal order?
It was brought on the record, my lord.
Where is that? By which sub?
Page 112, my lord.
Oh, this is part of the OA.
Part of the OA.
Yes. Yes.
There is a prescribed period, my lord, within 5 years. They did not prefer within the time frame, my lord. Thereafter, the competent authority rejected their appeal, my lord. Kindly see, my lord, for a moment, my lord, page 41, once again, my lord. In case you are not satisfied with the above decision, you may prefer an appeal to the appellate committee on first appeals within 6 months from the date of receipt of this letter by you.
So it is only 6 months.
6 months, maximum 5 years.
Where is that maximum?
In their page 112, they stated, my lord.
No, but it's not stated here. That's why we are asking. Here you say you have to do it within 6 months. You don't say within 6 to 5 years, 6 months to 5 years. Whereas in the order rejecting the appeal, you say the maximum permissible limit is 5 years. 5 years. You are referring some letter of the Ministry of Defense of 17/5/2016. Anyway, so that is not in dispute anyway. Now just allow us to go through the order, tribunal's order. So apparently it is relying on Dharamveer Singh.
Yes, my lord. My submission is an Air Force personal case cannot be decided by the FT on the army rules, my lord. First submission, my lord. Kindly see, my lord, page 205, my lord. Very interesting. I am relying upon this, my lord. Para 14 of the impugned order, my lord. Against this order, one WPCT filed, my lord, and an order was passed against us, my lords. Although I am relying on that order, my lord. Saurabh Biswas case, my lord. I have the judgment. Your lordship pass the order, my lord. Involving similar facts and circumstances. The state case was totally different, my lord. I have the judgment.
Show us.
This is the tribunal judgment. This is the my lord pass the judgment. In Saurabh Biswas case, my lord, respondent was injured during the training, my lord.
9-foot ditch. It is that one.
Yes, ma'am.
Where he has fallen in the 9-foot ditch.
Yes, my lord.
We had heard that matter.
Yes, ma'am. On the basis of that judgment, my lord, this impugned order has been passed.
On the basis of this?
No, on the basis of tribunal order, my lord. Saurabh Biswas.
But the tribunal's order we did not interfere with.
My lord.
Did not interfere, my lord. That judgment was decided in different footing, my lord. That is in respect of injury.
Yes.
My lord, may I
let me submit.
Madam, may I
allow him to complete? Give him 5 minutes. Yes.
In that case, my lord, respondent sustained injury in the course of exercise.
Yes.
In 2017, the same was recorded in the second appeal. A rejection thereafter, my lord, respondent sustained injury up till the review in February 2021. All the injury continuously recorded, my lord. Here the case.
We remember this matter. It's not very long ago that we had decided. March.
First matter, my lord.
This was the first case of AFT that.
I'm also relying upon this judgment, my lord. This case is not applicable in this case.
Very well. So you are saying that is a case of injury that will not apply. Here it is diabetes. You say it is a lifestyle disease.
Lifestyle disease.
They are on the ground that when they entered into service, they did not have any such disease. When they are being discharged, they have this disease. Therefore, the irresistible conclusion is that it is attributable and aggravated by military service. That is perhaps what they will argue.
But in the Air Force, it is not.
So show us what is the distinction. That's about it. Dharamveer case is under the entitlement rules.
Rules of army, my lord.
Correct.
Second, my lord, kindly consider. Kindly, before relying our kindly see our opposition, my lord. Opposition, my lord. Affidavit in opposition, my lord.
What is it you want us to see?
My lord, in the meantime, my lord, in the meantime, my learned friend, relying upon in his opposition, entitlement rules, which is totally covered by the Honorable Supreme Court's judgment. Also, my lord, the Saurabh Biswas judgment, where it is clearly said, Lordship, regarding this, at the time of the entry into the service, you.
Yes.
Kindly see page 126, my lord. Not a single point considered, my lord, in a
126.
Page 126.
You handed us the regulations. So which provision you are relying upon?
53, my lord. Our page 131.
So this, what was the name? Saurabh Biswas, you have complied with that case?
I have to take the instruction, my lord. I do not know. I am not the counsel, my lord.
If you can tell us, then it will be good, whether we should rely on this or not.
I have no instruction in this regard.
Find out, find out.
My learned friend is junior counsel in that matter, my lord.
So there was a rule. There also there was a distinction in the earlier entitlement rules and the later entitlement. You were saying that in the later entitlement rule, the concept has changed. So what is that rule? Just make a comparison with this Air Force rule. If there is no distinction, then nothing would remain.
On judgment, my lord, there is a that one compilation of judgment is there, my lord. This, I think, that blue color.
No, what rule 10 of the 2008 rules?
8, my lord. Sir. Yes, my lord. This is the distinguished, my lord.
What is the distinction?
It is in judgment, my lord. I kindly see, my lord. Blue color compilation. Kindly see this, my lord.
You have given us a copy.
Earlier we have given.
Let's see. Earlier they have given a copy.
Page 179, my lord.
where the Air Force rule has been considered. Air Force regulation.
Kindly see, my lord, there from page 52, my lord. 52. Up the 210, my lord. The interpretation, which rule is applicable? 82.
Sir, 82 and 2008 both are for military service.
Yes, this is my submission there, my lord.
So we are asking you, what is the distinction? You have given us the Air Force rules, regulation. You say that here it will not apply because here there is a different regulation. So the Air Force regulation, does it contemplate a different yardstick, or it contains a provision akin to 9 and 10, which says he will not be called upon to prove that it is attributable to the military service? That is what we have to see.
The entitlement rules in the army, my lord, there is a clause of presumption.
Correct. That's why we are saying they are not.
There is no such clause of presumption.
There is no such clause.
No such clause.
You have said so in your opposition.
My lord, kindly see page 131, my lord. We have stated rule 153, my lord.
153. You are relying on 153.
Yes, my lord. Page 131.
Then that is your submission, that because Dharamveer Singh was a judgment taking into consideration the entitlement rules for the army, there is no such provision here. Therefore, relying on that judgment, AFT should not have allowed.
One thing, my lord.
Yes.
Dharamveer Singh case judgment, my lord. Respondent was not discharged, but invalidated out of.
How? What difference does it make? He is under a different entitlement rules.
Invalidated, it means he is medically discharged.
Yes.
Here the respondent discharged on the completion of his tenure.
No, no,
No,
no.
my
He
lord.
was discharged. The time of his discharge, he was in LMC.
My lord.
No, my lord. Kindly see, my lord, unfulfillment our opposition, my lord. Kindly see, my lord.
Sir, he is placed in low medical category. You please see the release medical board.
Kindly see there, OA, my lord.
Yes, come to the release medical board.
Page 50. Kindly see for a moment, my lord. It is their application, my lord. Page 50. Paragraph 4.2. He was discharged from service.
Whatever they may say, it is your document. Come to page 31. Fit to be released from service in low medical category. That's your recording. That's not her recording. If she has not said, then you can't take an advantage of this.
Solely not on Not only on medical grounds, my lord. Kindly see.
Sir, you see what you have recorded that he is being released from service in low medical category.
So, I'm not disputing in this.
You can't dispute. That's why we said I had seen it. Therefore, I told you. Come to page 31. That is your recording in the release medical board that he has been released in low medical category. So that is not an issue. You are only relying on 143, 153 that we have understood.
There is a section.
And you say Dharamveer will not apply because that was considering the entitlement rules under the armed forces. Here the regulations for Air Force will apply. And there is no similar provision to 9 or 10 here in the Air Force rules. This is your case.
An appendix 2 of our compilation, my lord.
This one.
This one, my lord.
Appendix 2.
Appendix 2. This is known to be affected by dietary compulsion. Roman 5, 9. 7, Roman 5.
So this goes against you.
Kindly, why I am submitting, my lord? Kindly see.
This says that there are dietary compulsions arising out of a service. Now, because of such dietary compulsions, such diseases may get aggravated or.
He was advised in 2006, my lord. Kindly see
My lord.
page 127, my lord. Kindly.
Page
127. The air veteran was found to be overweight. Actual weight 68 kg, ideal body weight 61 kg. Overweight 11.4%. During annual medical examination dated February 15, 2006, my lord. There was a history of overweight, my lord.
Page 127.
127, Roman 3, my lord. FT did not consider, my lord. Neither this point nor my lord rule 153. There is a delay of my lord 5 years, 9 months, my lord. As per AFT Act, my lord, after 3 years. Yes. Page 32 also important, my lord.
32. You have already placed page 30.
Kindly see at the bottom there is a signature of the respondent, my lord.
You have already told us.
They did not challenge, my lord. Section 22 of the AFT Act, my lord. There is a provision of limitation, my lord.
Yes, that's all.
That's all.
What do you want to show?
Section 22 of AFT Act.
Section
22 of AFT Act.
Yes. Section 22.
Subsection 2, my lord.
Yes. Limitation.
Limitation, my lord. Anything contained in subsection the tribunal shall not admit. After the
No, but they are approaching the tribunal after rejection of the first appeal. They have approached the tribunal after rejection of the first appeal.
First appeal is not decided on merit, my lord.
Whatever it is, that is their that is what they are claiming their cause of action. This aspect the FT has considered. Yes.
Last submission, my lord. Respondent did not challenge the my lord impugned order. RMB, my lord.
No, they filed a first appeal belatedly, but they filed.
For the tribunal not challenge, my lord. Original order.
Without, yes, already. That's all. So why did you not challenge the rejection of your first appeal?
My lord, what my learned friend, my lord, tried to portray before your lordship, that is the RMB. My lord, the most of the cases, my lord, they didn't give up the copy of this RMB.
So you have said in the OA that we did not have a copy, therefore we could not challenge.
My lord, my humble submissions before your lordship. Here, my lord, after the first appeal, my lord, we made a RTI. My lord, though my lord, I have no annex in this in my way, my lord. So that's why I'm not onto going into this aspect, my lord, because this copy, my lord, they never ever served as a copy. So whether, my lord, whether that is the any point which can agitate it before the tribunal, my lord, the learned tribunal.
You have annexed the appeal order in your OA.
My lord, that is the only point, my lord, the way in the first appeal, the copy of the appeal, only the rejections. This neither attributable.
Did you challenge it? If you have not challenged it, how it can be?
My lord, we don't have the copy at that time, my lord.
You have annexed it in your OA.
My lord, in that case, my lord, that copy, lord, I have get from the another source, my lord, on the.
Wherever you have got it, when you have got it, why did you not challenge it? It's not that you are not having a copy.
My lord, most of.
Don't challenge the base order. Can you get any relief?
My lord,
so that order will also remain and you will get a relief. Is it?
No, my lord.
Cannot be. Why did you not challenge that order? What have you said in the OA about that order? Nothing.
My lord, I have nothing to say regarding this RMB, my lord. I have not on that, my lord. They ever said.
I'm not asking you about RMB. You challenge the finding of RMB in a first appeal. That first appeal was disposed of in 2018.
My lord.
You have not challenged the order passed in the first appeal. Why? You have enclosed it with your OA, still you have not challenged it.
My lord, in that case, my lord, regarding the copy, my lord.
May I interfere 1 second? Kindly see 192 for a moment, my lord. It is his.
Yes.
First paragraph, my lord.
झूठ नहीं बोल रहे
I
मैडम.
beg to say that since I was deeply engaged in my resettlement process, I lost some of my RMB paper. It means he had RMB paper, my lord.
We are not on that. Whatever he had, he has ultimately filed a first appeal. The first appeal has been disposed of. Then why he has not? He has chosen not to challenge the rejection of the first appeal, and in absence of challenge to the order passed by the appellate authority, how a relief can be granted to you?
My lord, if your lordship kindly allow me.
That is the first issue. That hurdle you have to cross. Then other things we'll see.
My lord, in that case, my lord, they denied my case on the basis of the Guide to Medical Officer Military Pension 2002 rules, my lord. That my learned friend also annexed in his affidavit in opposition.
No, they did not.
My lord.
They have only.
My lord, that is mentioned in they are already relying on these issues, my lord.
No. Come to page 112.
My lord, they mentioned, my lord. In my lord, actually, my lord, I have only one copy regarding this. In his opposition, my lord.
Whatever it is, again we are asking you the same question. In absence of challenge to the order of 11-10-19, can any relief be granted to you by any tribunal or court? If you choose not to challenge the order passed by the, we don't know if there is a second appeal or not. Probably there is a second appeal.
My lord, there is a provision for second appeal.
Why didn't you challenge it?
My lord,
neither in second appeal nor in the AFT. Then how relief has been granted by the tribunal? This was annexure to the OA, as we have been told.
My lord, that has been annexed by my learned friend, my lord. I suppose, my lord, in his opposition, my lord.
Show us from your OA that again and again we are asking you.
Well, my lord, my humble submissions, lordship, I didn't annex in my original application, my lord. If I'm not wrong, my lord, they annexed in their opposition, my lord.
Make a submission of which you are sure. Don't make a
My lord, if
submission
that be so, my lord, if your lordship kindly come to allow me, my lord, regarding this medical military guide to
we
military.
will not. Unless you overcome this hurdle again and again, we are telling you. Without a challenge to the first appellate order, how a relief can be granted to you? You are wanting us to skip this and go to the merits. How we can do it? How the tribunal could have gone into it? If there is an order of rejection, you choose not to challenge it, then a relief can be granted by a forum.
My lord, my submission is lordship regarding why I am totally, because lordship I'm subject to lordship's kind approval, my lord. I'm totally covered by honorable Supreme Court judgment Dharamveer Singh. And another point is there.
So that means you are accepting that you have chosen not to challenge.
So, my lord, at this moment I cannot improve my case, my lord. I cannot improve my case.
That's why we are asking you.
My lord, then lordship kindly give me some time so that I can take the instructions from my client.
Therefore, your instruction is to be borne from the OA. We have been asking you. We are going through it. Let us see what you have said in the. Yes, you have referred to it, para 4.2.4.21 at page 61. And you have annexed it. You have annexed the order also. Knowing well this fact, you have not challenged it.
My lord, may I come back, my lord? Allow me, my lord.
What will you do, madam? We are asking you. If you have not challenged, what can be done?
Well, kindly allow me, my lordship, at least 1 week, my lord. Kindly allow me, lord, so that I can try to satisfy your lordship.
Can you have given us the military entitlement rules. Can you give us this Air Force one? No, that you have already given us. Of this one. This we can retain. Get it spiral binded. Huh? Yes, you can. Give this.
I'm grateful, my lord.
This judgment. Yes. This judgment compilation you had given us in that case. Oh, yes, Saurabh, this was some case.
My lord, in the meantime, proceeding impugned stay, my lord. Otherwise, they will.
What is something precipitatory is happening? Otherwise, why?
Very
By
good.
9th September.
Number 110.
It is a separate matter. One 186.
One zero ten.
1010.
This matter, you want 186 to be taken up with this?
No, 186, I am not appearing.
Both the matter is that and
No.
Who is appearing in 186?
Miss Sonal.
No. That is not connected with this matter.
Let us see. Yes. We'll go by this case first.
Alright, I am for the petition. Now, dear Lordship, similarly matter already decided in respect of the can you see the Lordship's earlier order of this matter?
No, what is the earlier order in this case?
So covered by that. In that said list, petitioner before your Lordship in this matter also same. So that was decided. In that matter, one recalling application has been filed. She is running in the list at item number 186.
Oh.
Your Lordship desire the recalling application to be heard first. For
Then it should be.
Otherwise,
kindly hear out this matter first. Then I do not know whatever the facts there, whatever the contention is there. I don't have.
No, we are not asking you to appear. What he is saying is he is claiming to rely on a judgment which we have passed and they have applied for recall of the judgment.
in the list.
And that is in the list. So how he can rely on the judgment if it is a recall is pending?
Gita Noskot in this case are different. According to my
When one list had appointment given, I do not know how this type of submission is being made by a learned senior advocate. Serial number 14, serial number 26.
Kindly see the input order. Kindly see
just give us a minute.
Order.
Yes.
15 May 2025.
Yes.
We are ready to pay given absorption from 13 March 1996. And in spite of that, he is not entitled to get pension if 10 years service is not completed.
Oh yes, this issue we have decided in one case.
Taking consideration of past service since 1980.
Nimai Chand.
Here the finding is
Nimai Chand Chatterjee case.
Nimai Chatterjee is not applicable because in this case he could not produce any single document that he was appointed in 1991 in any post. But that is the finding by the learned tribunal.
No, what is the finding? That is before us.
Yes.
We will not rely on the finding. Show us from the documents.
Can you see our opposition? Can you see the opposition? Can you see our opposition? Can you see page 4?
Opposition.
Opposition paragraph 4. Page 4.
Brief. Which page of you have filed an opposition?
Yeah, page 3. Paragraph 4B. In terms of the Labor Department's memo number dated 13 March 96, read with memo dated 16th April 96, Director of Personal Ex officio chief engineer, irrigation and waterways. Kader Ali was still then engaged as a master role casual.
Just a minute, Mr. Mukherjee.
Sorry, Malad.
Yes.
Nimaichaji.
We have got it.
Which
page?
On a page 3, paragraph 4B.
You did not file a reply in the tribunal.
In spite of repeated direction.
Husband of the petitioner, namely late Kader Ali, was engaged as a master role casual deliberated labor prior to being absorbed as a work charge khalasi under labor law Damodar construction division under irrigation and waterways directorate government of Bengal worker in terms of labor department memo dated 13 March 96 read with memo dated 16th April 86 director of personnel and executive ex officio chief engineer irrigation and waterways directorate Kader Ali, who was still then engaged as a master road casual deliberated labor, was absorbed by Zappos memo dated 21st February 1997 in the post of work charge Khalasi under work charge establishment in the pay scale of 800 to 1,500 plus allowance at basic from time. Pursuant of the said order, Kader Ali joined the post on 13 March 96. Then page 4. Kader Ali rendered service from 1st May 97 to 31st March 97 and retired on 31st March 2005. 7 years, 11 months. How Nimai Chatterjee could be made applicable here?
When was he absorbed?
Absorbed on 13 March 1996.
96.
96. But joined on 21st February 97.
And why he was absorbed?
Absorbed because certain work charge employees, so Khalasis were there, that according to because this.
So that means he was working prior to his absorption.
No.
Then
he was working as a Khalasi as a work charge.
Obviously.
Master role worker.
That is what we are saying.
Master role worker.
Yes. So in recognition of his service, you have absorbed him.
That not in a regular way.
Whatever way, in recognition of the services rendered by him, you have absorbed him.
But at that point of time.
So prior to absorption, since when he was working? Why did you absorb him? Show us.
There is no such document.
Then why did you absorb him? Show us.
Whatever. Can you see that? Can you see the memo?
It is not that, he will come on 13/3/96 and you will say that come, we are absorbing you. He must have been working as a casual or contractual or khalasi something since when?
What a kindly see the page 13, 3rd August 1979. This is the circular.
We are not asking you, see that circular, whatever circular, absorption is always in recognition of some service rendered. Not circular, some service rendered. So what is the service that you have taken into consideration for absorbing him? Where is that? Show us. A person cannot be absorbed on the first day.
No.
So therefore, what service you have taken into consideration?
Master role employee in the.
Since when? Tell us.
No period is mentioned there.
Madam.
So your decision is without any basis.
Please, ma'am. No. In that sense, no.
No, this don't do this. Please don't do this. You wait. Yes.
Page 30 for a moment. Serial number 3, Kader Ali. Joining report. If he was working there, how that would be a joining report?
This is his joining after his absorption.
Absorption.
What are you saying? We are asking you, why did you absorb him? There must be some service preceding his absorption or regularization. What is that service?
Master role staff.
Since when? You don't know. Then why did you absorb him?
That is there. That is page 29.
What is your case? We are trying to understand. You tell us.
Master roll. Master roll staff. Because he was master roll worker, that's why it's coming under the pension scheme.
This page 29 is about this petitioner.
Yes. Service statement of Kader Ali ex
So he's been working since 1982.
82 to 96.
And you said that he has not joined before 91. But
No,
your
no.
document shows he's working since 82.
Not in a regular basis.
Obviously, if he's irregular, why you will regularize him?
And workshop from 96 years.
I'm so grateful. I was trying to.
Please don't become impatient, sir. We are not losing patience. Why should you lose patience?
এটা দিতে হবে। Okay, get to the double. Yeah, এটা দেয় কিন্তু। কোনটা দিই? এটা কেন দেওয়া দরকার? না। Before if he was what, and there is a finding by the tribunal that there is no such document. Can you see the word?
That's not in dispute. Your document shows that he's working since 82.
No.
Your opposition shows he's working since 82.
But no such document is available substantial from that employee has been working prior to.
That's why he is saying that the tribunal's finding is wrong. Because you have produced a
Can you see
document.
the Labor Department notifications?
Yes.
Labor Department notifications.
So therefore, Mr. Mukherjee, it may be better to hear it after the recall.
What?
It may be better to hear it after that recall. We were just trying to ascertain whether it is similar or not. As prima facie, it appears to be similar. You are appearing in that case also.
Yes. I informed Miss Sonal Sinha, who appeared. She left the court just after recess. She requested any day at 2 p.m. because my client is now as no pensionary benefit has been given. She is under the death bench. That is my paper, so that I can discharge my duties to my client. Any day at 2 p.m. tomorrow, day after tomorrow, she is ready to. Or this matter may be hard after this matter on that any day, same day itself. So
No.
I have to discharge my duties to my client itself.
No, we are also discharging your duties to my client. we are here for discharging our obligations.
So
to assist the court.
Both the matter.
What is the number? WPST?
Number 186.
WPST, sir.
In that matter?
Yes.
Yes, I am giving that.
Recall,
130.
a recall application has
Depending on the appellant, my lord, he's on leg at court number 11, my lord.
You can start. He will come.
A day's accommodation. My lord.
Let him come. Not today.
Complete.
Yes, yes, very satisfied. He's still in good progress.
But 112, I am appearing on behalf of Public Service Commission.
Should I appear on behalf of the state? Your Lordship, 12 and 13 are identical matters, right?
Yes, Lordship, 12 and 13, I am appearing on behalf of Public Service Commission.
This has been taken up earlier.
So, my lord, I'm instructing you.
Yes, can you give us a brief background? What is
But these are all, my lord, the Polytechnic teachers.
teachers?
They have been working continuously for more than last 8 years. Initially, they were appointed through a process of public advertisement, regular recruitment process. They call it walk-in. But they applied before this court for the purpose of regularization or absorption. This court directed, the tribunal directed them to consider they take the plea of Umade. Now again the matter came before the tribunal. The tribunal directs either you absorb them or fill up regular way through PSC. But that second part of the direction is offending me. If you direct that, kindly come to page 211, that is the order of the tribunal. But at the page 215, the concluding paragraph,
4/4/25. Order is dated 4/4/25.
Order is dated
4th April 2025.
Just give us a minute.
190.
Yes. Now, my lord, the recent position of law is something different. The Honorable Supreme Court made a recent judgment said that this you cannot utilize Uma Devi to prevent the deserved persons from getting the benefit.
His Lordship Justice Vikram Nath's judgment.
Yes. That this has been though reported, but they have downloaded it from the website. That paragraph 21 would be very relevant. Rather, paragraph 20, my lord. It is well established that decision in Uma Devi does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar and others, that they have quoted it, I am not troubling my lord with that. Then paragraph 21, the High Court placed undue emphasis on the initial level of the appellant's engagements and the outsourcing decisions taken after their dismissal. Court must look beyond the surface levels and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointments. In that light, refusing regularization simply because their original terms did not explicitly state so, but because an outsourcing policy was belatedly introduced, would be contrary to the principles of fairness and equity. The pervasive misuse of temporary employment contracts as exemplified in this case reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the, this is not relevant for our purpose, this is that the teachers in Polytechnic colleges, they don't say that the Polytechnic teaching is ad hoc. It is a permanent in nature. We have been continuing with the years together. And the learned tribunal says either you absorb them or undertake regular process, by that giving them a weapon in their hand.
Whether reply was filed by the state before the tribunal.
There was no denial, particular facts.
Denial. Reply is at page 151.
And similar issue has been decided by a division bench of our High Court, and a review petition was filed that was rejected. Page 192, 193.
So that was much prior to this judgment of the Supreme Court. I am told that he has informed me the matter is before the Supreme Court. The Supreme Court has issued notice.
The review petition has been rejected.
Ekhane.
Against this order, judgment of Justice Sodistan and Supreme Justice Samanto, that has been rejected. A review petition has been rejected.
So relying on this apex judge?
No. It is 2021.
Oh.
Judgment was 27 December 2021.
That's a long judgment that thereafter Supreme Court has come. What is that?
No, that is no. Latest report has not been reported.
Copy that, okay.
I should also understand.
Well, you come from a state where people do understand Bangla.
When you speak so fluently, then I miss out. But sometimes
I was just telling him, have you gone through the judgment?
Oh.
Without going through the judgment, you agree. Take a copy and.
So let him have a look.
Yes.
Go through it. Because your pleading is already there before the tribunal. Therefore, I asked you. Nothing is to be filed now. You only have to make a submission. He says that this judgment now paves the way for consideration for absorption.
Whether the
or
issue of
whatever.
the judgment could be made applicable or not.
Just see. So
Hey, God,
this is not reported yet.
it has been reported.
Must have been.
I have gone through the reported judgment. Unfortunately, they have
I
downloaded.
think I have also seen the reported one.
This is reported in 2025.
Yes.
February, March.
25.
The Mr. Bhattacharya and keep it on 4th.
Let it 4th, yes.
4th.
On safe side. 12, 13, same order.
Huh? This is what 12. So the next one also.
13, 12, 13, same back.
You are appearing in both.
Yes, yes.
No, I'm appearing 13 my land fund.
So please give your appearance. They are all teachers from the Polytechnic.
Yes.
So a common order can be passed. Common order just recorded.
Aki order.
14.
Well, I'm for the respondent. Swapun Banerjee is Mr. Swapun Banerjee is for the appellant, my lord. Pursuant to your lordship's direction, this is the affidavit.
You have served?
Yes, ma'am. This is the service one. This is the service one.
Affidavit in opposition is taken on record.
No. Appointment. There is a long delay. The order sheet, including the.
What are you filing?
I'm filing pursuant to the application and copy of the order where it is reflected that the judgment is pending, my lord. There is, my lord, application. My lord, have a look too.
Application. You have not filed any application. Where is your application?
Yes, ma'am.
This is an
Yesterday,
affidavit.
my lord, that is not incorporated with the appeal filed by Mr. Swapun Banerjee. The application.
What are you filing? We are asking you.
I am filing the application for condoning delay and its order.
As a respondent.
Last order. Last order.
You are for the respondent.
Yes, ma'am. এর মধ্যে order sheet টা কোথায় দিয়েছে?
Then as a respondent, why you are filing an application for condemnation?
And then, it was verbally directed me to file this, the application file in condoning delay in the trial court below.
Oh, so you are bringing on record what application you have filed in the tribunal, all right. We had asked you whether you had sought a condemnation or not. In response to that query, you are filing.
In respect of appeal, I am not filing any application. I am just briefing the record brought to the record, my lord.
Which appeal? Where is the appeal?
That is filed, the application filed by the state against the compassionate appointment.
We are unable to appreciate which appeal you are talking about.
No, my lord, I am not saying appeal. This is an application for WPST. I am not filing. I am just supplementing by verbal direction. Your lordship directed me to file the application for condoning delay in the
You are the applicant before the tribunal.
No. Yes, my lord. Yes, my lord.
You need not say no to everything. You are the applicant before the tribunal. Probably an issue arose whether you had sought condonation before the tribunal or not. To dispel that query, you have filed an affidavit placing on record the details of condonation application filed before the tribunal. All right. So, saying appeal and this and that. Yes. Huh? State. Who is appearing? Take this on record. An affidavit is being filed.
একশো 14 হ্যাঁ 114 তো
115.
Lordship, I appear for the respondent.
Impugned order is dated 6th of May 2022, passed by Armed Forces Tribunal, Kolkata. But the order was passed, my lord, without any opportunity to the respondents to give any reply, my lord, on its initial day, my lord.
What is the date of filing of the application?
The application, my lord, was filed in 2022, my lord.
How many dates prior to this order? What have you said in your writ application? Let us see.
Probably the date of filing is not there, my lord. My lord, the date of filing is not there, my lord, but in 2022, 6th of May 2022, my lord. The impugned orders date, my lord. Order number 1, my lord. Order serial number 1.
So you were the applicant.
Well, I'm the applicant.
Then how can you be aggrieved by non-filing of a reply?
No, that I'm stating, my lord. That is a fact, man.
No,
It's a fact.
so your case has been considered.
Yes, my case has been.
If at all they were to be aggrieved by such a procedural error.
That is true, man.
Yes. They have not challenged the order. So you have to tell us why the order is not sustainable.
My lord, previously, another order was passed by AFT, my lord, in my case, where my disability pension was rejected, my lord. Thereafter, my lord, after coming into force of the Dharambir Singh's judgment, I had made some applications, my lord, that let my case be considered, reconsidered, my lord. In reply to one of those, my lord, in 2016, the my lord, answer came to me, my lord, on 4th of
When were you released?
Yes, my lord, I was invalidated out of service.
When?
My lord, I was invalidated out on 4th November 1984, my lord.
84.
84, my lord. 75, 18th October 1975, I was enrolled.
Yes.
And 4th of November 1984, I was invalidated out of service, my lord. The total qualifying service was 9 years and 17 days, my lord.
So no service pension also.
No service pension, my lord. And my lord, what initially, my lord, the disability pension was.
Where is the release? Where is the invalidation order?
My lord, the invalidation medical board, my lord, is there. It is at page 29, my lord. Page numbers are rounded, my lord. Page 29. Next, A1, that is also part of the.
So this disease, can it be attributable and aggravated by military service?
My lord, as per the military guidelines, my lord, this can be only if it is in high altitude, my lord. Only my disease is schizophrenic psychosis, but my lord, only one psychiatric illness has been mentioned, my lord. Only one psychiatric illness has been mentioned in the GMO, my lord, which engulfs each and every psychiatric illness. My lord, that is the fact, my lord. But now, my lord, I am before your lordship with another issue, my lord. My lord, the issue is that if I am not entitled to disability pension, my lord, I am well entitled for a invalid pension, my lord. But the lacuna is that, my lord, the minimum qualifying service for granting invalid pension is also 10 years. And even when there is a provision for condonation of delay in qualifying service for all other cases, this case, including 2 other cases, my lord, have been expressly kept away from the scope of any condonation, my lord. That I had agitated before the AFT, my lord, but Honorable AFT was not satisfied with me, my lord. Hence, I am before your lordship, my lord.
No, before the AFT, you have also approached another AFT and a High Court.
Yes, my lord. I had,
where are those orders?
My lord, the order of the previous AFT, my lord, is at page 40, my lord. Where, my lord, the question of condonation was not agitated, my lord. It was decided only in regard to the disability pension. Page 40, my lord.
So by a series of litigation, you will urge all the points.
No, my lord, not series of litigation, my lord. I cannot, my lord. I cannot do that, my lord.
Then how are you saying that this was not considered and now I will agitate this, and then in a third proceeding you will agitate a third point?
Well, that is not a. Well, I have to keep myself clean, my lord. I had approached the AFT.
You have
Lucknow
no
bench, my
case
lord.
appear apparently. What can be done? And where is the High Court order? There is a High Court order also.
High Court order was not with the applicant, my lord. I have searched in the net also. Because it is old, my lord, I could not
What is
find
the
it in
date of the order?
It was CWJC number 4651 of 1988, my lord. By this, my lord, it was rejected, my lord, due to lack of territorial jurisdiction. Subsequently, my lord, WP number 34515 of 1997 was filed before the Allahabad High Court, my lord. That was transferred to AFT, my lord. This AFT order is the last one, my lord. Of
Case
AFT
44.
40, my lord. Both the Patna High Court and the Allahabad High Court order number, case numbers, my lord, are mentioned there.
And what was held by the Lucknow AFT?
Well, Lucknow AFT held me not entitled to get disability pension.
And why you are entitled to invalid pension?
Well, because invalid pension, my lord, only I can get if my disease is either less than 20%, which is not the case in my, it is 20%, my lord. And if it is held to be nana, my lord, then if I am not entitled to get disability pension, then I am entitled to get invalid pension. Only one lacuna is there, my lord. The minimum qualifying service, my lord, in case of whereas in disability pension, there is no.
That is an admitted fact.
My lord, that is the reason I have sought for a condonation, my lord. That
Under
is,
which provision?
my lord, the provision that is there, my lord. My lord, the provision is there, but that applies in respect of second service pension and what the government is holding, my lord.
Show us the provision.
Yes, ma'am. Yes.
Which you are relying upon.
But this is from the pension regulations for the Army 1961, my lord. Regulation 125, my lord. Near the bottom, my lord. 125. My lord, there is a provision for condonation of delay, my lord. Yes.
Your Lordship, I wish to use an affidavit because there are